three branches of government: judicial, executive, and legislative, and they're supposed to be co-equal, checks and balances. Well, the Supreme Court just gave itself, the judicial branch, more power, and at the same time took significant power away from the executive branch in a ruling that is going to change everything for all of us. So stick with me. This is a long video, but I promise it is important. So if you don't have time to watch it right now, favorite it, do whatever you have to do, and come back to it when you have a few minutes. In a 6-2 ruling, the conservative majority just shattered the 40-year precedent of the Chevron Doctrine. Now, I know you've been hearing a lot about this already, but I'm going to show you a real example of how this works so you can see exactly how this is going to apply to you. So Justice Kagan wrote the dissent with Justice Sotomayor. For the record, Justice Jackson recused herself from this case because she was involved in it while she was still a federal district court judge. This bombshell ruling came down yesterday in two cases. Both were questioning the legal authority of a federal agency to interpret laws that Congress passes. Since the country's founding, federal agencies have been responsible for taking the laws that Congress passes, interpreting them, and then figuring out how to apply them to the real world. Well, lots of people and companies sue the government because they don't like the way the agencies interpret and implement those laws. So in a 1984 Supreme Court ruling, the justices created a legal test that basically says, when there's ambiguity in a law and there's a question about the agency's interpretation of it, judges should generally defer to the federal agency. The theory was these federal agencies are staffed by people who work for the government, who are experts in their field and understand, based on their experience, how to apply new law to the real world. I know that doesn't sound like a big deal, but what you might not know is when Congress passes laws, the process generally resembles something like this. I'm the big ideas person, you agency. You figure out the details. So here's a real example. The Clean Air Act was originally passed into law in 1963. Now, it's been updated multiple times, but in the original law, Congress's big idea basically was, we should probably have clean air in the United States, and we should probably set a standard for what is considered clean, and we should also probably put some kind of cap on the amount of pollutants that these big corporations in our country can spew into the air. But when it came to the details, like what should the standard for clean air be, and at what level should pollution be capped, and how often should those caps be updated, Congress left the details up to the Environmental Protection Agency because lawmakers know they aren't air quality experts. They just know they want clean air, so they left it up to the experts to figure out how to get there. So let me read to you from the actual law so you can see how vague most bills are written. You're in for a treat. The administrator shall within 90 days publish and from time to time thereafter shall revise a list of categories of stationary sources. So those are building structures or facilities capable of creating pollution. He shall include a category of sources in such list if in his judgment it causes or contributes significantly to air pollution, which may reasonably be anticipated to endanger public health or welfare. Within 1 year after the inclusion of a category of stationary sources in a list under subparagraph A, the administrator shall publish proposed regulations establishing federal standards of performance for new sources within such category. So when the EPA did what Congress told them to do, you better believe the coal industry sued, the oil industry sued, and everybody under the sun on that list came out of the woodwork to also sue. They don't want to be regulated. That cuts into their profits. But in the past, when they went to court, the Chevron Doctrine would have been applied. And generally, with some exceptions, the courts would have said, well, Congress's big idea was they wanted clean air, and they told the EPA, which is full of scientists and experts about clean air, to figure it out. So if they say those specific buildings, structures, and facilities are the sources of pollution, sorry, coal industry, sorry, oil industry, you lose. But in yesterday's majority opinion, the Chief Justice says the Chevron Doctrine is over. He writes, perhaps most fundamentally, Chevron's presumption is misguided because agencies have no special competence in resolving statutory ambiguities. Courts do. The framers anticipated that courts would often confront statutory ambiguities and expect that courts would resolve them by exercising independent legal judgment. This means in the future, when there's a question about the sources of air pollution in the coal or oil industry sues, the courts are not going to defer to the expert opinion of the EPA. The case is going to have to be heard from both sides equally, and then the judge is going to have to make a determination. But this isn't just going to apply to the EPA. It's going to apply to everything. Literally, every law Congress passes is vague. They're the big ideas people, not the details people. Congress delegates those details to these agencies because they know they're not the experts. So this ruling will have ripple effects on everything in your life. Healthcare, cars, food, Social Security, taxes, criminal statutes, your job, your student loans. I mean, I could go on and on. So people who support yesterday's ruling say this is a huge win. They say the Chevron Doctrine had to go because these agencies were just getting too big and having too much power. But in her dissent, Justice Kagan lays out the chaos we're all about to see and questions whether the courts should have this much power. She writes, Congress knows that it does not, in fact, cannot write perfectly complete regulatory statutes. It knows that those statutes will inevitably contain ambiguities that some other actor will have to resolve and gaps that some other actor will have to fill. And it would usually prefer that actor to be the responsible agency, not a court. Agencies report to a president, who in turn answers to the public for his policy calls. Courts have no such accountability and no proper basis for making policy. As if it does not have enough on its plate, the majority turns itself into the country's administrative czar.